morning and welcome to a session of the 5th PCA. We have on my right Judge Sawaya, on my left Judge Hedstrom. He's a visiting judge from Palatka, and that's our far outreach frontier for this district. We thank him for coming and sitting with us. We only have one case this morning, and so we look forward to hearing your oral argument.
I'd like to make an announcement. As we all know, Judge Sharp is retiring at the end of this month, and that is unfortunate for all of us, I think. And this is her last oral argument session, and so it is a particular honor and privilege for me to have the opportunity to sit with her this last time. Her contributions to this court as a founding member, her contributions to the jurisprudence of this state, and her contributions to the citizens in her service over the long length of time that she's been a member of this court, I don't think will be equaled by anybody else. And so it's with great pleasure and also with great sadness that I have the opportunity to sit with her this one last time. And so I wanted to make that announcement and commend her for her public service.
Thank you. Sort of overwhelming. Here. All right. We have a civil case that's 20 minutes per side. We have a clock on the podium, which I will try to run. And if you want to reserve some time, appellant, you may. Just let me know. So let's hear your case.
Good morning, Your Honor. May it please the Court. My name is David LaCroix. I'm attorney for the appellant in this case. Opposing counsel is Teresa Jones. And Judge Sharp, it's an honor to participate in your final oral argument.
Well, thank you.
Try to make it agreeable. This is a fairly simple case, and it doesn't involve any issue of evidence. It's strictly a legal issue concerning the...
Counsel, could you talk a little louder? I'm getting a little elderly, and I'm having trouble hearing you.
What about the Nichols case out of this court, which was just affirmed by the Florida Supreme Court a day or two ago? Does that necessarily end the discussion of this case?
Your Honor, I'm sorry, I'm not familiar with it.
You're not familiar with the Nichols decision from this court?
Not by the name of it.
Okay.
I remember having cited the case because it did hold, as many other cases, that a motion for attorney's fees should be as specific as possible. But off the top of my head, I don't remember the particular facts in that case.
All right, then I won't question you about it any further.
Well, this case does involve an award of attorney's fees because of a rejected settlement proposal. And the award was made under Section 768.79 of Florida statutes, which the courts have held repeatedly must be strictly construed because it's in derogation of the common law. And Florida courts have also held repeatedly that a proposal for settlement to be enforceable must be devoid of any ambiguity, latent or patent, that it must be capable of execution without further explanation or judicial interpretation, and that virtually any settlement proposal that is ambiguous is not enforceable. The settlement proposal in this case proposed to settle the case for the sum of $60,000 and incorporated by its terms an attached release form. The release form said that the release was to be given in exchange for a payment of $59,000. Therefore, there was a patent ambiguity between what was said in the proposal itself and what was said in the release that was incorporated into it. That settlement agreement could not have been executed without further explanation or without judicial interpretation. The appellees say that this was just...
Wasn't the figure of $59,000 followed by $60,000 in writing, or vice versa?
It was $59,000 in writing, followed by $60,000 in parentheses.
Why couldn't we say that that was just a typographical error?
Well, that's the argument the appellees have made, though. What was the typographical error, the 60 or the 59?
Well, I mean, obviously, the other document referred to 60, didn't it?
Yes, sir, it did.
All right, so you've got two documents referring to 60, one document with a typographical error of 59,
Right.
and then 60. So why can't we just say that, it's clear it was just a typographical error and that, we don't need to go any further?
A court could say that.
Well, why wouldn't that be?
Because it requires a court to interpret the document. It's ambiguous and cannot be the basis of an attorney's fee.
What interpretation is there if we say that it was just a typographical error? I mean, you've got it twice in both documents, but one document has it 59 in figures and then 60,000 spelled out. I mean, so we just say it's a typographical error. What interpretation is there to that?
Which is the typographical error? Do you just weigh 2 against 3 to determine which it is? We don't know that.
Is that the sort of ambiguity that they're talking about? For example, I mean, I asked you about the Nichols decision, but you're not that familiar with that. But is that the type of ambiguity or mistake that they're talking about, in rendering the offer invalid?
Well, this court in Jameson v. Curland in 2002 said that a settlement proposal said it was for the $200. And later in the document said it was for $200 written out, paren, $1,000 in numbers. Was ambiguous and could not be the basis of a fee award. So there was $200 spelled out twice, written twice, and once in parentheses, $1,000 that created the ambiguity. How is that any different than the ambiguity in this case?
Well, for
Somebody had
example,
to interpret.
for example, I believe in Nichols, for example, there was a provision for a general release, and they didn't know what claims a general release was to apply to. So they had no idea what claims are going to be extinguished in exchange for the offer and the settlement. And so yes, that's ambiguous because you just don't know. I mean, it could vitiate a UM claim or a PIP claim or whatever, or a claim against another tortfeasor. But here we have two specific documents with specific figures, but one document, has an erroneous, has a mistake and designates the figure differently. But right next to it, we have the correct figure. And is that the sort of mistake or ambiguity that we're talking about in rendering, the offer of judgment invalid?
There's been a lot of litigation about offers of settlement and attorney's fees awards on them, and the courts have repeatedly held that any ambiguity is sufficient to deny an award of attorney's fees. And there may have been other defects as well in Jameson, but in Jameson the court said specifically that confusion between the two different numbers was a sufficient ambiguity upon which to deny an award of attorney's fees.
Well, why is it ambiguous if you say, I will settle, for $60,000? The person thinking it was $59 would be very happy, right?
Yes, but which is the one you have to pay? If you have to pay $59,000 or $60,000, that's the ambiguity.
Well, if you're paid $60,000, you certainly can't complain when you're expecting $59.
No, and in Jameson, the person who was supposed to be selling for $200 couldn't object if they got $1,000 instead, which was the second number that created ambiguity. It's no different in this case. I mean, I can't imagine how a court could hold in one case that there's no ambiguity because...
But the offer said 60. The offer said 60, and the release suggested maybe 60 or 59.
One or the other. And so which one was it supposed to be requires explanation or judicial interpretation.
Was there, in fact, a misunderstanding or an ambiguity between the parties?
The parties didn't talk. The offer simply wasn't accepted, and by operation of the statute, it was rejected. I can't say they didn't talk, but there's no indication in the record that they did. But there's also another ambiguity or a problem with this particular offer of judgment as well. And that's the second legal issue that I've raised. The statute very specifically requires, and there have been many decisions involving this particular issue recently, that an offer made on behalf of more than one defendant or made to more than one plaintiff has to specifically designate the amount of the offer that's applicable to each plaintiff or defendant.
Was this really a joint offer?
Well, it was made ostensibly on behalf of one defendant, but it required a release of both defendants. So, in effect, it was a backward way of effectively making an offer of judgment for both defendants.
But isn't that done in many cases? A single person says,
Maybe.
you have to release these two other people before I will pay this.
Right. And there are some cases that say, if we're simply talking about somebody who, is not a party to the suit, if I'm a corporation as a defendant and I want to release not only of me, the defendant, but also of my officers and agents, you can make that one of the conditions of the offer if you spell it out clearly. But there are other cases that say when you're talking about two defendants in a case, you have to specifically identify how much is being offered on behalf of each so that a plaintiff and a court can make an intelligent decision.
What if the mistake was a $50 mistake? What if the offer was $60,000 in both documents, but instead of a $1,000 differential, it was a $50 differential? It was a minuscule amount.
I've never read a case yet that said a small ambiguity is okay, but a large ambiguity is not. Cases uniformly say if it's ambiguous, it cannot form the basis of an attorney's fee.
He's going to now ask you about a penny.
Yeah, what about?
What if it's just one penny?
Ambiguity is okay.
So no matter how small it is, I mean, that's as long as it's there, that renders it invalid.
Well, hypothetically, yes, but we're not talking about that here. We're talking about $1,000.
Okay, but I'm trying to figure out how far do we go with this? I mean,
Well, so
we
far-
got $1,000. I mean, how about 500? How about 100? How about 50? How about 5 or 1?
Well, so far the decisions have said any ambiguity. If you'd like to write an opinion that says, here's the line between an ambiguity that's acceptable and an ambiguity that's not.
Fortunately for me, Judge Sharp will do that for us.
You're not supposed to know that.
Judge, I can't make a line that thin myself. So
Let me ask you about this differentiation argument which you make. Your second point? Opposing counsel said you didn't raise it below, so we can't consider it here. What do you say to that?
well, I have two responses to that. First of all, trial counsel at the hearing gave the judge a copy of the statute which says what's supposed to be required and argued that everything has to be met for it to be sufficient. Then the discussion went on to the dollar discrepancy because that was the big issue. But regardless of that, you don't have to raise something if it's fundamental error. And fundamental error is defined by the courts as one which gives someone relief or benefit to which they're not entitled by law. And if the statute does not entitle somebody by law to an award of attorney's fees.
Was this Lamb case decided by the Supreme Court in effect, or had it been rendered by the time this trial took place or this hearing?
Which case?
The Lamb case, which more or less talks about differentiating.
The only ones I've seen, and I'm sorry, I do not remember cases much by the names. I remember them by what they have.
Okay.
So, but all the cases I have seen have said very clearly that if you're talking about an offer from two defendants, it has to differentiate. If you're talking about an offer made to two plaintiffs, it has to differentiate. All of the cases cited by the appellees in their answer brief dealt with an offer by one defendant or an offer to one plaintiff, and none of them involved one where the differentiation had to be made. Some of them involved a release of non-parties, which again the courts have said is okay, but when you're talking about releasing both parties, the problem is I as a plaintiff have to be able to determine, do I accept the one and reject the other? Do I accept the other and reject this one? Or do I accept or reject both? And without differentiating what that $60,000 or $59,000 represented in terms of both defendants, I can't make that decision.
Well, when one party is only vicariously liable, does that make any sense at all?
I think it does, because vicarious liability is consistent. And who knows if that party is liable at all? I may not want to release that party. I may want to release the other. And still sue this party on the basis of the vicarious liability, if they are in fact vicariously liable. I may want to accept the offer on behalf of the person who's only vicariously liable and get that issue out of the case and not release the other. But when you don't differentiate the settlement offer, They can't make that distinction. Neither can a court make that distinction in determining whether or not a judgment was more than the amount offered on behalf of each defendant, or less than the amount offered on behalf of each defendant, because there's no differentiation. There's one other legal issue that I'd like to discuss, and that involves the motion for an award of attorney's fees on appeal. And, you know, there's every district court in the state has awarded attorney's fees on appeal under that statute. But none of them have directly addressed this question. And that is, the courts say uniformly that you have to interpret that statute strictly regarding award of attorney's fees because it's in derogation of common law. The courts have also said, and the Florida Supreme Court has twice said, that interpreting contractual provisions for attorney's fees, you have to interpret them strictly. And because of that, the courts have said, if a contract does not mention appellate fees, they're not awardable. So if you're strictly interpreting a statute and strictly interpreting a contract, because both are in derogation of the common law, how can you interpret one to include appellate fees when it doesn't mention them, and the other you have to interpret it as not including appellate fees because they're not mentioned? There are some Florida statutes that do mention attorney's fees on appeal, including Section 627 and 428. So if the legislature wanted to change the common law with regard to awarding fees on appeal, it can certainly say that in 768.
Did you say there's a split in the DCAs on this issue?
There's been no decision yet that has dealt with this question. Every DCA in the state has just routinely awarded fees on appeal, but I'm not aware that any has dealt with this question because it's not mentioned in any opinion that I can find.
So you say they're all awarding them?
Yes, ma'am. So, and if you uphold the decision in the trial court and get to the issue of awarding fees on appeal in this case, I would ask that you simply address that question and rule one way or another. Can a statute be interpreted differently than a contract when they're both supposed to be interpreted strictly against awards of attorney's fees? And that way I'd have a basis of taking it on further on that one particular issue, if that's the result.
Counsel, you've got about 4.5 minutes left. Would you like to reserve some time?
Thank you.
Thank you. Please, the court.
Good morning, Your Honors. My name is Teresa Jones. I represent Stephen McManaway in this case, as well as Hartford Insurance Company, who was joined as a defendant for the purpose of enforcement of the final judgment. I will start off by quoting the proposal for settlement, which is part of the record on appeal. That proposal in pertinent part says as follows. Comes down the defendant, Stephen McManaway, vying for undersigned counsel, and serves this proposal for settlement in accordance with Florida Rules of Civil Procedure, Rule 1.442, as follows. This proposal is made pursuant to Florida Statute 768.79. The party making the proposal is Stephen McManaway. The proposal is made to Lucy STASIO. Skipping to paragraph 5, the amount which will be paid on behalf of Stephen McManaway to Lucy STASIO is $60,000. Those are the pertinent terms of the proposal for settlement. There's nothing ambiguous about those terms. Those terms are certain. They state the party to whom the proposal is being made, the party who is making the proposal, and the amount of the proposal, period. Now, we do acknowledge that there is a typographical error in the release. However, that doesn't change the fact that this proposal on its face complies with 1.442 of the Rules of Civil Procedure and the case law which has interpreted that section as applies to ambiguities. Now, Jameson versus Kirkland has been cited as the authority by appellant. That case presents a completely different situation than the situation here, because in that case, the amounts which were proposed...
Didn't this court hold in Nichols that it has to be free of any ambiguity? And as I said before, that decision was just recently affirmed by the Florida Supreme Court a day or two ago.
Yes, Your Honor. Your Honor, as I recall the Nichols case, in that case there was not a release attached to the proposal.
What about the language that says it has to be free of any ambiguity? And if that's the case, why can't we say that, or why shouldn't we say that this is an ambiguity that poses a problem?
Because there is no ambiguity in the proposal. The proposal says...
There is one in the release, though, and the release says in writing 59 and then numerically 60. And counsel says he's, confused and doesn't know which number applies and therefore renders it invalid.
Reading the proposal says 60,000. It is no different than if we had put in the release for and in consideration of the sum of $10 and other good and valuable consideration. Could that be argued as an ambiguity? No, because...
Well, no, but here we have the two specific figures in the release. And so, which one is it?
It is the amount which is set forth on the face of the proposal, which says the amount being offered to Lucy STASIO is $60,000.
So you're saying that that's no ambiguity at all, that it's perfectly clear that it's $60,000.
It is $60,000. We do not believe that there is an ambiguity. We acknowledge that there is a typographical error. But when you look at the proposal says we offer you $60,000, period.
But the release says 59.
That's true. The release could say anything. The release could set forth any consideration at all. But the proposed amount is still $60,000.
Counsel, the rule says that state with particularity any relevant conditions, or the particularity with regard to the release, in my mind, creates the ambiguity. Because you attach the release to it.
The release was attached to the proposal in an abundance
as a relevant condition, correct?
In an abundance of caution, and I believe if you look at the proposal itself, it indicates there are no conditions, however, as a part of the formality.
But there was. He had to release the other person.
I'm sorry?
Isn't release to the other defendant in the release?
It is, as well as in the proposal itself. It says the proposal shall include the following conditions. There are no conditions, however, as a part of the formalities to conclude the settlement. Lucy STASIO will sign a full and complete release of Stephen MCMANAWay, Gail MCMANAWay, whose liability is only vicarious, and their insurer, a copy of which is attached, and will file a dismissal with prejudice of this lawsuit.
Well, that sounds like conditions to me. You can say they aren't.
Your Honor,
what do you do
while that issue has not been addressed in this appeal, that verbiage in the proposal was as a direct result of case law from the 2nd District Court of Appeals.
We can't help you with the 2nd District Court.
I understand. Cited with approval in the Nichols case, in which the 2nd District said it is not a condition of settlement to attach a release that is a part of the formalities of settlement. Now, I understand the Nichols case and its holdings, because in the Nichols case, the argument was made that, as I recall, State Farm was not only the carrier whose liability was being requested to be affected at the trial level, there was also an issue of PIP benefits, which were still outstanding. And because the Nichols proposal said, we will, this will take away all rights that you have against State Farm, and of course I'm paraphrasing there, this court felt that there was an ambiguity because of the argument raised about the PIP. We don't have that here. This is strictly a liability case. And so that being the case, we have the proposal with the specific amount from a specific party with a release, and
Well, Counsel, isn't the release the document that effectuates the proposal? I mean, isn't that really the most pertinent part of the whole legal documentation, is the actual release itself? Without the release, what would you have?
you would have a conclusion of the case with a dismissal with prejudice.
But without the release, would you have to go to court to get some actual release of the legal liability absent the release?
In this instance, in this case, no, because by the time that this case the proposal was served, as I recall, the statute of limitations had run, and by virtue of a dismissal with prejudice of all of the claims in the case as set forth in the proposal to effectuate the finality of the case, that would have done away with everything. You didn't necessarily have to have a release. They could have accepted the $60,000 and then filed a dismissal.
Would your insurer pay the money without a release?
If they had accepted the proposal and said, here's a dismissal with prejudice, it would have been done.
If you write a check and you make the same kind of mistake, which one controls, the numbers or the writing?
I don't know. I was asked that question at the trial court level, and I don't know, and I looked briefly to see if there's any case law, but I didn't find anything.
Well, our industrious law clerk said it's the UCC, and that says it's the writing control. So 59 controls over the 60.
But the amount that was offered,
I know I appreciate your argument.
was $60,000.
But I have written a check when I screwed up, and I often wondered which is controlling. Now you know, and now I know.
I can only analogize, as I have in the brief and as I've argued, that when the Cornell versus Floyd case, which was cited by appellant, says that what a proposal is to do is to place the person to whom the proposal is being given in a position of having to make a hard choice instead of rendering him unable to evaluate what his choices are. The hard choice in this case was whether or not Ms. STASIO was going to accept $60,000 and do away with all of her claims in this case. I don't think that there was ever any issue until the tail end when this motion was filed and the appellant came into the trial court and said, oh, by the way, Judge, there's a typo or there's an ambiguity and therefore this is no good. I mean, it was never raised at any point prior to the final hearing. There were
well, isn't that your job? I mean, you don't put the burden on the other side who receives an ambiguous proposal to come back to you and say, what do you mean? You know, which number controls here? That's your job.
Your Honors asked appellant's counsel whether or not there was any question of how much was being offered. And
well, I don't think they have to do that until you come back for fees.
correct. But in response to that question, being trial counsel, there was never any question that $60,000 had been offered. And I don't think that there was ever any issue at all. Had the plaintiff at the trial level done a notice of acceptance, there would have been a $60,000 check paid or judgment entered, proposal for settlement entered, period. There was never any question that the amount that was being proposed was $60,000, notwithstanding the typographical error in the release language.
You saying they didn't argue that at the hearing?
No, I'm saying that it was never brought up in any of their pre-hearing pleadings.
Pre-hearing, okay.
Correct. What happened was, at the trial level, judgment was entered. There was a motion for attorney's fees and costs. And there was a motion for rehearing. The judge denied the motion for rehearing, hands down. Then there was a request for rehearing of the motion for rehearing, motion for new trial, which the court considered and granted, and then briefs were submitted, if you will, memorandums of law. The issue was never raised in any of the memorandums until sitting down at the final hearing, and for the first time, the issue was raised. I don't think there was ever any question that the appellant knew that it was a $60,000 offer. That's what it says on the face of the proposal. As indicated in the Jameson case, which is a different situation from this case, on the face of the proposal, there was an ambiguity, because in the wording of the proposal itself, there was a notation of $200, and then later on...
Counsel, did you address whether this is a joint proposal? And whether
I have not talked about that.
Well, but you briefly reached that.
Sure.
Because you're running out of time.
This is not it is the appellee's position that this is not a joint proposal. This is a proposal from Stephen McManaway, one defendant, to the plaintiff, asking for payment of a certain amount in order to dispose of the whole case, put an end to the litigation. Now, in all of the case law which was cited, there is no similar situation to the way this was done. In the Lamb
Including your cases, right?
including my cases, no question about it.
Right.
So this may be a case of first impression. The Lamb case, Judge Perrienti mentioned that while, and I'm going to paraphrase, of course, we're not going to tell you how to do these things, but we're sure that some clever lawyer in the state of Florida can come up with a way to do it which will be acceptable. That was cited in an article in the Florida Bar Journal, which was cited in my brief, in which the author of that article suggested that it is possible that compliance could result in abandonment of the joint proposal for settlement as a viable tool for settlement purposes, and a reliance upon proposals by one defendant conditioning acceptance of the proposal on a release including all defendants. So this proposal predated this article and predated the Lamb case, because the Lamb case was decided, I believe, in the summer of 2005, and this case was actually tried in February of 2005.
That's what I wanted to know, whether the Lamb case was out there.
The Lamb case was not out there. A whole bunch of other cases from jurisdictions that conflicted, et cetera, were out there. So the way to do it was unclear. And it's still unclear in my mind, because it wasn't really answered by the Supreme Court. They simply said, we're sure you'll figure out some way to do it that will pass judicial muster. I would submit that this is an appropriate way, as suggested by the article of the Florida Bar Journal, to handle a proposal in a situation where you have a defendant who is vicariously liable only. In this case, Gail McManaway was simply the title owner of the vehicle. She did not operate the vehicle. She had no knowledge of the accident which gave rise to this cause of action. So Stephen McManaway was the operative driver. He was the person who was being looked to for the responsibility for the accident.
So you really could differentiate here, because there's only one person paying.
That is correct.
The other defendant's paying nothing.
I'm sorry?
The other defendant who's vicariously liable would be paying zero.
Well, interestingly, The first proposal for settlement, which was done in this case, and it's not of record, so I don't know, probably shouldn't be mentioning it, but in very early stages of this case,
It's in the record?
no, it's not.
Okay, sorry.
The slide, I don't want to go there, but at the stage when this proposal was served, we were very aware of the rules against joint proposals for settlements. Hence, that is why the proposal was made by the one defendant only. But it was to conclude all of the litigation period. So this is not, we don't have any judicial guidance on this kind of situation in how to structure this type of proposal.
Okay.
Thank you, Your Honors. We would submit that the trial court was correct in the decision on granting the attorney's fees. With regard to the appellate attorney's fees, if Your Honors do affirm this case, I don't have any case law to submit, as much as counsel doesn't have any case law to submit on the issue that was raised. Thank you.
Okay, appellant. You got 4 minutes.
Thank you. Ms. Jones has said that it didn't matter what the release said. So what if the release said, you know, it was an offer for $60,000, but the release said you have to release everybody in consideration of the payment of $400,000? That sort of raises an ambiguity in my mind. What if it said you have to release everybody in consideration of the payment of $4? That's also an ambiguity. Why is it different because it says 59? And in terms of defense counsel or counsel for the plaintiff not raising this issue before the hearing on the motion for attorney's fees, if I had received that offer, I would look at it and say, it's patently ambiguous. This can't be the basis for an award of attorney's fees. No sense even dealing with it.
Well, unfortunately, it appears that this is just the beginning of the litigation regarding what's ambiguous and what's not when it comes to the offer of judgment statute. I mean, it looks like this is just the beginning of what's going to be a long history of litigation regarding that particular issue. What is and what isn't ambiguous?
Well, I agree, because the line right now is any ambiguity. And I don't know how that line could be drawn any differently myself. But since the statute's in derogation of the common law, why shouldn't the line be any ambiguity? It's supposed to be interpreted strictly against awards of attorney's fees. And the thing is, in this case, they didn't have to attach a release. They did not have to incorporate a release into the offer of judgment. But since they did, they introduced an ambiguity. Appellees have cited one real source with regard to the issue of the joint proposal, and that is a law review article written by an insurance counsel. Well, I'm certain any insurance counsel would say the same thing, and we can draw them however we want to, and you're stuck with having to deal with them. And it would have been a simple thing for this offer to say it's made on behalf of both defendants, and we're offering $60,000 for Stephen and nothing for the other defendant.
But isn't that in essence what it did?
It did, but the rule says you have to differentiate.
But not if the other person is not paying anything.
Maybe their intent was $59,000 for Stephen and $1,000 for the person who's only allegedly vicariously liable. We don't know. Maybe that's where the ambiguity came.
That's very creative.
That's really stretching.
Well, that may be where the ambiguity came in the release. But regardless, it's not plaintiff's counsel's job to figure out what was intended. It's supposed to be clear and specific, and it's supposed to differentiate between any defendants included in the case. And both defendants were effectively included in this settlement proposal. And unless any judge has another question, that's all I have to say.
Okay, thank you very much. Thank you, counsel. Very interesting argument. That will conclude our work for this morning, and thank you for coming all the way from Sarasota, was it? Yes.
Thank you all for coming, too.